All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, February 6th, 2024. We have 14 bills on the docket, and we're going to start off with Senate Bill 287. We're going to go to 256, 262, 280, 270, 251, 260, 273, 282, 275, 254, 267, 277, and we'll end up with 285. So right now we'll start off with Senate Bill 287. Department of State Police Professional Occupations Application Process. So if we could have, yep. How are you? Welcome.
Good afternoon, sir.
Up the podium, yeah. Thank you.
Good afternoon, Mr. Chairman and members of the Senate Judicial Proceedings Committee. I'm Catherine Kelly. I'm the Director of the Maryland State Police Government Affairs Unit. I have with me today Captain Rosignol, who is our Licensing Division Commander, as well as First Sergeant Hickey, the Commander of our Professional License Section. It would help if I put my glasses on. We're here to testify in support of our departmental bill, Senate Bill 287. I'll give a brief overview of the bill. Captain Rosignol and his team are here to answer any questions you may have. We've submitted some lengthy amendments with our written testimony to ensure a few licenses and certifications that were missed by the original bill are included. We'd like to thank the DLS staff who identified the missing language. Senate Bill 287 as amended will allow the Secretary of the Maryland Department of State Police to change the application process for all professional licenses to include private detectives, security guard agencies, security system technicians, railroad police, and special police from a paper process to an electronic process. This committee has been central in the efforts to provide the authority for MSP to convert other processes to electronic, such as the sale or transfer of regulated firearms, handgun permits, and the handgun qualification license. Once the conversion to electronic processing is completed, the applicants will receive all communications via email as opposed to US mail. If a license is issued, then the licensee will receive renewal notices via email as well. This will make the process easier and more efficient for applicants. The electronic payment component will make the process more streamlined and reinforce program accountability. This is the last phase of our automation project. I ask that the committee give Senate Bill 287 as amended a favorable report, and we're happy to answer any questions you may have.
Excellent. Thank you very much, Ms. Kelly. We'll take questions at the end of the panel. That's it? Okay. Questions from the committee? Seeing none, look forward to working with you.
Thanks,
Excellent.
sir.
Thank you both. Thank you all three of you. Thank you. All right, with that, that'll conclude the hearing for Senate Bill 287. We'll now move on to Senate Bill 256. Okay. Is Mr. Silver or Mr. Enton here? If not, we'll bump them down and take them at the end of the day. Excellent.
Good afternoon, Senator Smith.
Good
My name is Wayne Silver. I'm the Executive Director of the Maryland Police Training and Standards Commission. With me today is Mr. Matthew Milady. He is the Deputy Director of the Police Training and Standards Commission. Good afternoon, Chairman Smith, Vice Chair Walt Stryker, and members of the Senate Judicial Proceedings Subcommittee. For the record, my name is Wayne R. Silver. You should have our written testimony before you, so I will keep my remarks brief. The Police Training and Standards Commission is an independent commission housed within the Department of Public Safety and Correctional Services, which establishes officer certification standards and training requirements for approximately 16,000 police officers in the state. Senate Bill 256 will have a positive operational impact on the commission as it clarifies language that has been subjective and realigns all training mandates to the same section of the statute. This will enhance the auditing capacity of the commission and staff while ensuring that over 150 law enforcement agencies throughout the state receive mandated training on a specific schedule. It requires a more extensive mental health evaluation as opposed to a mental health screening by requiring a mental health screening every 2 years to maintain certification. The suggested bill will direct the commission to conduct a regular job task analysis and ensure entry-level training is current and relevant. The proposed changes remove initial legislative language that impose requirements to develop standards and policies that have already been developed and implemented, replacing such language with continual monitoring and revision of these standards and policies as necessary. It also removes the references to the law enforcement officer's Bill of Rights as it relates to commission hearings. Additionally, Senate Bill 256 provides statutory mandates that every police officer must be certified by the commission and adds regulatory language that currently does not exist. Mr. Chairman, that concludes my testimony, and we're happy to answer any questions you may have.
Thank you so much for your testimony. Questions for this witness? Senator Sidnor.
Thank you very much. And if you can help me, the legislation that, okay, it does. I have a question, page 5, line 11. I'm curious, the intent of making the Secretary of State of Police the chair of the commission. What's that about?
Oh, sir, Senator, thank you for the question. That's actually an amendment has been removed so that the chair will still be nominated by the members of the commission.
Okay, and you mentioned some regulatory language, because this commission, is from my understanding, hasn't necessarily been a regulatory type of entity. So could you point to where that language is regarding what regulatory powers we're giving it?
Actually, Senator, we have regulatory authority based on the certification standards of a police officer. That is just getting into changing the language from a mental health screening to a mental health assessment, which is consistent with what law enforcement agencies are currently doing.
Is that because I know the ARC, they had sent a letter of information noting that they felt strongly that we should not be removing language on page 8. Say lines 4 through 9 and lines 16 through 17. Would you mind addressing why that language is being stricken?
Yes, they have contacted us. We believe that was unintentional omission when some things were moved to another section of the bill. However, the commission, if given the authority, will still be able to direct the law enforcement community to conduct that training during their in-service programs.
But wouldn't it be better to have it in the legislation so that everyone understands, rather than, I mean, again, I guess some things, given what's happening at the federal level with the Chevron case, you wonder, should we just leave something rather than relying on you all to do it, just leave it in?
Certainly.
Okay. Thank you.
Thank you.
Thank you. Good question. Senator West.
Thank you, Mr. Chair. This is a long bill which contains lots of requirements for police training. And my view about police always has been that we want the best trained police forces in Maryland in the country. So in adopting these significant changes, especially on pages 8, 9, and 10 to the current law, and 8, 9, and 10 spell out in great detail the nature of the training that's going to be required. Have you checked other states to make sure that Maryland's training is going to leave our police officers, once they receive this training, second to none in the country?
Thank you, Senator. I can tell you this, I've been the executive director for a little over 2 years now. Maryland has some of the most robust training standards in the country, and this does nothing but enhance that. What this section really does is many of those training requirements already exist. So what it allows the commission to do is actually assist us in an auditing capability, because a lot of the language now ties into providing certain training, mandatory training with every 3 years. Well, when our auditors go out, instead of looking at 1 year to conduct that audit, they have to look at multiple years, and it may be multiple years for the same agency, because they send their folks to different in-service training, especially the smaller agencies. So I'm very confident that the requirements, if they're not being met, they are being met right now because they're mandatory, right? Which this is just streamlining when they have to do it, to kind of put them on a schedule.
Great. because my thought has always been we should train the policemen as best we possibly can. And then if in the field, they do exactly what they've been trained to do, no one should be able to complain about how they discharge their duties.
Absolutely. The other benefit this does give us is that if something comes up and the commission reviews, say, an incident or a crisis event, they could direct the commission could direct law enforcement agencies to provide that in-service training without needing the General Assembly to pass a bill. It would give them the authority to do that.
Terrific. Thank you so much for your answers.
Thank you, sir.
Additional questions from the committee? All right, seeing none, thank you all very much.
Thank you, Senator.
Thanks. With that, that'll conclude the hearing for Senate Bill 256. We'll now move on to Senate Bill 262. Oh, there you go. Welcome.
Mr. Chairman, members of the
Welcome back.
committee. Thank you. Great to be back. So we have two bills for you. I'll start with 262. Pleasure to be here. Secretary Lee sends her warm regards. She's under the weather, but I'm sure she would love to be back here. A lot of fond memories and late nights. So I know you guys are hard at work. I'll take up just a small bit of your time. And
I'm sure she misses us tremendously.
I'm sure she does. I'm sure it's mutual too. So Senate Bill 262, this is a cleanup clarification. We had an audit a few years ago that identified that the unrecovered funds from charitable enforcement, the late fees, should be collected by CCU. And that was never really the intent of the legislature. The language is a little unclear. The auditors thought the unclaimed fund should be collected by CCU. I'm going to tell you briefly why we think that's inappropriate, and the language of this legislation will clarify that. It's not going to change our functions, but what it's going to do is make sure if we get audited again, they will be clear that those funds should not go to the central collection unit. So what we do is we try to bring charities into conformity with the law, and we want to bring these charities to stay registered in the state so that the people that donate, that are generous, have an idea that these charities are spending the money for the intended purpose. And what happens if a lot of charities have rollover, you've got new board members that weren't there when past board members might have had late fees. We try to bring them into conformity. We work with them. So this bill makes it absolutely clear that we can suspend or cancel the late fees so that we can bring them into conformity. It's really that simple. This is a clarification, what we thought was already our responsibility. There is an amendment that we're requesting for the review from our legal counsel who's behind me. If he can join later if he's needed. I identified some concern with the drafted language because it might put us back where we began, where there was an interpretation that we should actually have a duty to collect these fees. It's actually the duty of the charity itself to provide it. If we don't collect it, we just want to keep this a clarification bill. We don't want to change the substantive language in the statute itself. So that's why we think the amendment would be helpful. We've made that request through your office this morning. Yeah.
Excellent. Questions from the committee? Senator West.
Thank you, Mr. Chair. Is it your practice to give notice to these charities if they don't pay their fees on time, so they don't just get their license revoked?
Absolutely. And we actually have a new IT system in place, so they should get that notice automatically. So if they don't respond to that, they obviously can accrue. There can be additional fees, but now it's automatic. So they'll get that notice and hopefully they'll bring themselves into conformity. If they do not, we work with them. We just want the clear statutory authority to work with them. No one wants to go to CCU.
Good, because I suspect there are lots of charities out there that are not terribly sophisticated and could easily let this deadline pass. And we wouldn't want their license to be revoked without giving them a chance to notify them and give them a chance to pay up.
Exactly.
Thanks.
And you can how you doing, Mr. Sling?
Good, Harry.
All right, look, you can respond with a yes or no, but isn't it your practice that after June, when most of these registrations are due, that the state gives an extra 3 months for compliance?
Yes.
Yeah, we they get an extension of really 4.5 months. So they get 10.5 months after their fiscal year ends to file. There is also a 60-day called a grace period baked into the law before they actually get assessed a late fee on top of that. So they get about 12 and a half months before they would ever accumulate a late fee. So yeah, there is extra time built in before that happens. And he said they get a few notices now from the online system. They're getting 3 or 4 before they ever get assessed a late fee now.
Yes.
And we're hoping to try to get them to comply before they're late.
And I will say, because this is something that I have to deal with professionally across the United States, I appreciate the way that the state of Maryland does this, because generally when it comes to 990s charities, they're usually not ready in May and June. They usually take a few more months before they have their 990s prepared. And I'm assuming that's what you all see as the case.
Yes, we changed the regulation probably about 7 years ago or so. They used to have to request their extensions like to do the IRS. So we just made it, if they're current and compliant, we make it automatic. So they don't have to request the extension. We know more often than not, you're exactly right. The 990 is not done May 15th or November 15th. They're asking for that extension till, a later point. So
that regulation change is awesome. So thank you.
Hey,
Yeah. And
Thank you.
For the record, this is Mike Schlein, who's the director of the charitable and legal services division. He just had a promotion, so he's the head of our division. Obviously, he's our subject matter expert, as you can tell.
I like hearing that though. That was a good idea. It's our brainchild there. Some of the folks in the office. Good.
Further questions from the committee? Well, give the secretary our best. We wish she could be here with us today, but I hope she gets about well soon. And congratulations on your promotion,
Thank you.
sir, both of you.
Yeah.
I guess.
Hey, thanks.
Yeah, there you go. All right. All right. With that, that'll end the hearing for Senate Bill 262. You'll be right back for Senate Bill 280.
Great. Don't have to go very far. This is an even more straightforward bill. We are, upon the request of the comptroller's office, repealing reference to a form that does not exist. So the notary protest is something that can happen, but it's not something that you need a form to accomplish. The comptroller's office was trying to transfer that language of a form to our office because we do regulate notaries. It's also within Mike's portfolio, but the form doesn't exist. It doesn't need to exist. So we just want to repeal the section of code.
Some questions from the committee? Seeing none. Oh, actually, Senator Muse.
Explain it a little bit more, go give
Sure.
some concrete examples of when this would be applicable.
Sure,
I mean, as it is now.
it's exceedingly rare. There are
Okay.
certain groups of people that bring this up a lot of times inappropriately. So this is a notarial act. So the notary itself, it's referenced in commercial law 3505, which is in the testimony. And you could protest a certificate of dishonor. And it mentions the United States consul or vice consul or a notary public. So the form in statute references references a form in statute to do this process. We can do it without a form. So
Okay, so it doesn't.
it's just eliminating a reference to a form that doesn't exist or it doesn't have to.
Okay, thank you.
All right, seeing no further questions, that'll end the hearing for Senate Bill 280. Good to see you both.
Thank you. Good to see you.
Thanks a lot.
Thank you, guys.
Okay, we'll next hear from Sledge for Senate Bill 270.
Good afternoon. I'm not Rachel Sledge. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. My name is Rafael Lopez, and I serve as the Secretary of the Department of Human Services. I'm joined at the table today by the Director of the Office of Adult Services, Greg Sessick, and also behind me, I'd like to take the opportunity to welcome publicly our new Executive Director of the Social Services Administration, Dr. Aldra Studstill, who joined and serviced the people of Maryland beginning January 24th. And I thought it was unfair to put him on the record, not quite knowing exactly all the pieces of the workings of our department quite yet. We respectfully request your favorable report of SB 270. We are driven by 12 core values that represent the Moore-Miller values. Among these values are being data-driven and heart-led, reminding us to rely on data and experiences to drive our decisions. The data tells us that despite their important role, many adult public guardianship review boards face challenges due to vacancies across all 24 jurisdictions in Maryland. Currently, 23 out of 24 jurisdictions have board vacancies. The adult public guardianship review boards in each jurisdiction meet regularly to evaluate the health and welfare of the individuals under guardianship and make recommendations to the court regarding the continuation, modification, or termination of guardianship. SB 270 proposes to streamline membership requirements for the Adult Public Guardianship Review Board and to reduce the number of board vacancies across the state of Maryland. In 1984, these review boards were created to review all guardianship cases held by public agencies, including local departments of social services and the area agencies on aging. Area agencies on aging serve as the guardians of the persons for adults aged 65 years of age and older. Local departments of social services serve as guardians for adults aged 18 to 64, and you know all of those in your own counties as the local departments of social services. And they continue serving as guardians for our customers once they reach 65 to ensure continuity of care. Specifically, SB 270 would change the number of members on a review board from 11 to 8 members while maintaining multidisciplinary expertise, allow a psychiatric nurse practitioner or professional with experience in prescribing or oversight of mental health medications to serve in place of a psychiatrist. And many jurisdictions struggle to find psychiatrists who can devote the time to serve on these review boards. The change would also address the challenge while ensuring each board has the requisite knowledge and expertise about prescription medications. A full guardianship review board is essential to protecting the 1,700 Marylanders under public guardianship at this time. We review each of those boards reviews each case twice a year, conducting approximately 3,400 reviews each year. Again, we respectfully request your favorable report of SB 270. Thank you for your time, and I'm happy to answer any questions you might have.
Thank you very much, Mr. Secretary. Good to see you. Questions from the committee? I've got one quick one. Why going from 11 to 8? Why you have an even number of board members now?
Sure. We actually took a look at the roles across the jurisdictions and wanted to combine some of them to actually make it easier to find and recruit people to serve. For example, we took a look at all 24 jurisdictions and looked at the patterns of vacancy over multiple years to make the recommendation. Similarly, the proceedings of the review boards are used to make recommendations to the court. So it's not an issue of necessarily having an odd number. We want to be thoughtful about the kinds of rules to make it more effective. We know, for example, there are some jurisdictions that actually have viable candidates who want to volunteer, but they're stuck in the jurisdiction process to be officially confirmed and appointed to those boards. So trying to make it easier both on the jurisdiction, whether it's a county commission or county council or a city council or mayor, for example, and also the staff who are helping run those boards.
All right. Thank you very much for that. Thank you, Secretary.
Certainly.
Thank you. All right, with that, that'll conclude the hearing for Senate Bill 270. We'll now move on to Senate Bill 251. These are feeling like budget and tax hearings. I like it. They always talk about how many bills they have every year. Senate Bill 251 is Cleveland Friday. Here. Are they still over in the house or there?
Good afternoon, Chair Smith. My apologies. I am coming from the House testifying, so I apologize for being late. My name is Carolyn Scruggs, and I'm the Secretary of the Maryland Department of Public Safety and Correctional Services. With me today is Mr. Cleveland Friday. He is the Commissioner for the Division of Pretrial Detention and Services. We are here today for your consideration for Senate Bill 251, Correctional Services, Division of Pretrial Detention and Services Facility. SB 251 is a simplistic bill that removes language referencing the Baltimore City Detention Center, or BCDC as it is known. BCDC closed in 2015 and was demolished in 2021. And the new language will reflect the Baltimore City Booking and Intake Center. The bill also adds language to reference the Youth Detention Center, or YDC, which is the department's newest facility built in 2017. Simply put, this is just a cleanup of language to remove old references and insert new. As it relates to legal matters involving the department, it is important for statute to reference current facilities. We request the committee vote favorably on SB 251, and we are happy to take any questions.
Thank you very much, Madam Secretary. A question from Senator Carter.
Thank you, Mr. Chair. Nice to see you, Secretary, and I don't have a question. I just wanted to say, how dare you come to us with this controversial bill?
I wish they were all this controversial, ma'am.
But I do look forward to your support as we go down the line at trying to clean up some of the things within the system, the correctional system that have been in place for such a long time, as we move down the road toward women's pre-release and as we try to get rid of whatever the new term is for solitary confinement. I don't know what it
Restrictive
is.
housing.
It's changed like 50
Changed.
times.
Correct.
So, and then also, try to figure out how we can keep not separate babies from their moms within the prison system.
Absolutely, ma'am. My goal is to change the trajectory that we have on the Maryland Department of Public Safety and Correctional Services so that it is a more positive exemplification of how our professionals work.
Thank you.
Also look forward to working with you on home detention monitoring as well. I know there's a lot of good work to be done there.
Yes, sir.
All right, seeing further questions from the committee? Madam Secretary, Mr. Cleveland, Friday, Ms. Friday. It's not Friday, but you're here. All right. Thank you both very much.
Thank you.
It's great. All right. With that, that'll conclude the hearing for Senate Bill 251. We'll now move on to Senate Bill 260.
That's how my bill said.
Secretary's hanging out.
Good afternoon again, and for the record, my name is Carolyn Scruggs. I'm the Secretary of the Maryland Department of Public Safety and Correctional Services. With me today are Ms. Martha Danner, Director of the Division of Parole and Probation, and Mr. Walter Nolly, the Deputy Director of the Division of Parole and Probation. S-Bill 260 removes the burden of being current on supervision fees in order to receive earned compliance credits. So many individuals are compliant with all aspects of their supervision except the supervision fee, which currently makes them ineligible to earn compliance credits. Many of these individuals are trying to get their lives back on track, and being behind in supervision fees should not result in a status of non-compliance, nor should it be a barrier to start over without prejudice. We request the committee vote favorably on Senate Bill 260. I'm available for questions.
All right. Thank you, Madam Secretary. Questions for the committee? Seeing none. Thank you very much. All right. That'll end the hearing for Senate Bill 260. We'll now move on to Senate Bill 273. Welcome back.
I think all three of them were mine, sir. So again, just for the record, I am Carolyn Scruggs, Secretary of Maryland Department of Public Safety. With me, I have Mr. Earl Eddings, who is our Director of Intelligence and Investigation for the Division of Public Safety and Correctional Services. SB 273 will simply refer to as the drone bill. This bill will prohibit the operation of drones over a state or local correctional facility for the purpose of delivering contraband or taking photographs or recorded images. The use of unmanned aerial vehicles or drones has been increasingly used to conduct unauthorized surveillance and to bring contraband into our correctional facilities, including drugs and weapons. Drones threaten the safety of the incarcerated population and correctional officers, not only through the contraband brought in our facilities, but photographs and recorded images taken by drones threaten the physical safety of the correctional facility and the officers protecting it. And it exposes security vulnerabilities by showing an aerial view of staff rotations and movement of the incarcerated population. You may be familiar with the investigation last year that resulted in the indictment of 15 individuals for conspiracy to smuggle illegal drugs and other contraband into the Roxbury Correctional Institution. At least one of these incidents involved the use of drones to fly over contraband into the secured perimeter of the fence. While the department is able to charge incarcerated individuals who conspire to bring in contraband by drone, it is limited in the ability to pursue charges against the operators of drones who are trying to introduce contraband into our facilities via drone. The passage of Senate Bill 273 will provide investigators with an additional resource to pursue charges against these individuals. We request the committee vote favorably on Senate Bill 273.
Thank you very much. Questions from the committee? Senator Sidnor.
Thank you very much and good afternoon. I believe when I served on judiciary, we had legislation that was introduced like this, and one of the issues that I believe while this kind of bill wasn't passed in the past was us just trying to figure out how you deal with different facilities. I mean, you can have a facility in Western or Eastern Maryland that's away from and set apart from communities, or you can have a facility that's in smack dab in the middle of Baltimore City.
Mhm.
And while I don't have an issue with 9417.1, my question centers around the misdemeanor of the intentionally photographing or otherwise recording images of correctional facilities, and how that works or would work in an urban area without essentially completely prohibiting people who may live in that community from using drones in their own community.
So, sir, and thank you again for that comment. We are not in any way trying to stop the use of recreational drones, but as you know, our facilities are secured. So if it comes beyond the perimeter fence, which is a secured environment, that for us then becomes a concern. Again, as I spoke in my comments, it's a concern because of the movement. They now know when the incarcerated individual is out in the yard area, when they're not. They are able to see vulnerabilities within the plant where they could drop substances. So this bill is more catered to making sure that we remove vulnerabilities associated only with flying over our facilities.
Okay, and that I understand.
Okay.
But I also know that with many of these drones, one doesn't have to be over the facility to take photos of the facility and inside the facility. And my read of lines 8 through 11 could capture those who are not flying within the walls, but even outside, and images, again, in these urban areas that go up, the facility could be captured. So I'm just wondering if there's any thought to, how one addresses that.
We would still investigate it. But certainly if there was no intent of malice there, then there would be no further investigation needed. Earl, you want to speak further?
Yes, we've had drone incursions downtown Baltimore and out west there on both occasions. Very cognizant of the fact that it's an attractive place to fly a drone over. Somebody be interested in that. So the idea is to give us another tool. More on the deterrence prevention side. We do have a drone detection system that works very well, and it just give us another thing. So our idea would be like trespassing. You'd warn the person in the circumstances, don't fly over or don't violate the space, come down in there. But we've literally had them drop drones down from, and I'd rather not tell the specific places, but I'm sure, sitting at a location in Baltimore and dropping the drone, it's kind of neat to see it on the video where it just drops right down into the yard there.
Right.
Fortunately, it's got hooked up on sometimes on the barbed wire and stuff. So it is a problem, but the idea is, so not to go on at length, but our drone detection system, since we've initiated, the drone encounters have dropped about 43% because of that. So one of the things we'd like that enable us to do is to put up signage so people won't go. The idea is, but it's not directed at a hobbyist or anything like that. And the idea if somebody was trespassing, they stumble on your property through innocence, they just say, don't come back again. This is, prohibited. And
This is,
the
but this
other
is what
thing
I'm,
is,
but this is what I'm thinking though. The way this language is, a hobbyist, even, they'll send it up. Well, let me take a step back. You said that some of this stuff has happened before in the past. Without this law, how have those folk been dealt with you all?
in when we can make the absolute contraband case, and we did in the case of Roxbury Correctional Institution, where we actually charged the drone operator with that. But this is more on the prevention side, because there was in the encounter with the drone operator, we had an encounter previous to him, but he continued on there. And so with the law where we say, don't fly it over there, you're in violation, that would put them on notice, and just it's give us another tool in terms of that. But I understand, what you're saying. From if you're across Greenmont Avenue, you can just have a standoff, right? And you can see in. So I would think, and again, it'd be for that we want to have it so you're violating in our space when you're looking in.
Yeah, I mean, I might be interested in just getting some photos
Some
of
kind of
I-83 or or one of the
So
the
I think-
shot tower and
Yeah. And the thing with the recent Ravens game where you might have seen where they're charging he was over the stadium. He wasn't like standoff. I think they had a wider area, but he was over looking, he was actually in the stadium doing that. So
the people who were the hobbyists, did they have to get an attorney to deal with anything?
Well, what we would do with the RCI case, we have 2 attorney generals that specifically work with our department for contraband smuggling and stuff. So it'd be we would go to the AGs and say, what do you think should be done in this case? So we really don't have to charge somebody right away. So there would be a review on terms of that.
What if it's not a contraband case and I'm sending it up and I have photos and I trip whatever it is that is tripped by you all? What happens? Do I get some letter from the Attorney General?
Well,
a threat of prosecution?
It would be dependent again on the circumstances if you'd identify the people. So say we see you operating and we go over and say, are you operating the drone? Identify the person, check them out, and then check with the AGs to see it's appropriate. Because the idea really is deterrence. And so we can get the people that are really interested in introducing the contraband, that we can focus on them. So and then we put signage up, drone activity prohibited over our facilities and that sort of thing.
So if I may, the intent is not to have an I gotcha, because we will definitely provide warning. But if you look at our data related to last year, we had over 256 breaches.
256.
And many of them were right within Baltimore City. Many of our facilities in Baltimore City are adjacent to low-income housing and to other areas. And I understand. So again, it's not I got you, it's a deterrent, and that we will provide warning first if there is investigation to show that you had no intent, that it was a mistake. We're not going to just prosecute you for no reason.
And if I might ask, what does the warning say? I mean, is it a letter?
So that is something that we're working with the AG now to determine how that warning will go out, if that is a notification that comes from my office or from the Office of the Attorney General.
And with the warning, again, I guess I'm just having this trouble kind of figuring out.
So let's use an example. If the bill was passed, the warning would, say based on the law, you are prohibited from flying an aerial vehicle over a state prison or jail facility for the purpose of contraband, and please be mindful of your use of that drone during your practices of flying the vehicle or the device. And so again, it will not, I think you're trying to prohibit us, if I understand you correctly, from falsely accusing individuals, and that's not our intent.
No, and it I mean, really wouldn't be falsely accusing, because if they're flying it and they got an image, they did it. That's okay. Where I am. But then as I'm listening to you, you're talking about flying over, and you don't necessarily have to fly over to violate Section B.
Because that's when they fly over, that's how we got the drops. A lot of the drops were because of fly over, because you want to get the contraband within the secured perimeter.
Right.
If it falls on Greenmount Avenue, it's not in our secure perimeter.
But outside of dropping packages or contraband, we're also talking about photography and video and collecting images, which where you don't have to be over, you can be away and recording in.
Mhm.
And again, that's where I am. I'm listening and I'm trying to figure out how the language can be addressing what it is that you're asking about, but also not getting hobbyists who happen to live in these low income communities because they're using drones where they live.
Mhm.
So
Okay.
I appreciate your answers. Thank you.
Thank you.
Thank you very much, Senator Sidor. All right, further questions? Seeing none, thank you both very much.
Thank you.
Thank you,
Thanks.
sir.
All right, that'll conclude the hearing for Senate Bill 273. We'll now move on to Senate Bill 282. Ms. Sample, did you want to come up as well, or?
Good
Welcome.
afternoon. My name is Bethany Young. I'm the Director of Policy for the Governor's Office of Crime Prevention and Policy, or GOCAP. I'm here to testify in support of Senate Bill 282 and request that this committee report favorably on the bill. GOCAP's role is to advise the governor on criminal justice strategies, to coordinate across public safety agencies, and to allocate resources statewide to advance public safety. One of our focuses is the implementation of medication-assisted opioid use disorder treatment, or I'll refer to it as MAT programs, in jails under Section 9603 of the Correctional Services Article. One of the specific duties our agency has is reporting the data that jails collect in regard to MAT program implementation. SB 282 proposes a very modest change to the law. It removes 4 redundant data elements required by Section 9603 because as they are redundant, they are captured elsewhere in the data reporting requirements. I'll reference each data element by its number in the bill, beginning on page 5. The first of the 4 elements we're requesting be removed is item number 5 on page 5 that requires jails to report the number of people diagnosed with opioid use disorders. That information is already captured by item number 1 in that long list. We're requesting the removal of item number 8, also on page 5, which requires jails to report the number of medications by type provided by the jail. That is captured by number 4. We're requesting the removal of item 11 on page 6, which requires jails to report the number of people who initiated treatment while incarcerated. That information is captured by item number 3 on the list. Item number 14 that we propose removing on page 6 requires jails to report the number of people who received medication before being released back into the community. That is already captured by items number 4 and number 13. Among other things, the county's named onerous and confusing data reporting requirements as challenges to MAT implementation. This bill is a small step towards removing those obstacles and improving statewide implementation. My colleague, Brandy Kahn, who is the Assistant Director of Justice Reinvestment Programs, will speak in more detail about the support that GOCAP has provided local jails in implementing MAT programs, what the challenges are, and how we're working together to address those challenges. And with that, I ask for a favorable report on the bill and pass it over to Brandy.
Good afternoon, Chair Smith.
Come take the podium. Thank you very much. We start next.
Good afternoon, Chair Smith, Vice Chair Waldtrager, and members of the committee. My name is Brandy Kahn, and I am the Assistant Director of Justice Reinvestment. It's an honor to be here with you today to testify in support of SB 282. Since enactment, our office has worked closely with the local correctional facilities on implementing the Opioid Use Disorder Examinations and Treatment Act of 2019. As a result of the COVID-19 pandemic, many of our facilities were significantly delayed in implementing the requirements of the act by the mandated deadline of January 2023. To increase compliance of the act, our office contracted health management associates to provide technical assistance through in-person site-specific consultation, weekly virtual learning sessions, and an in-person learning collaborative. In total, 18 of our counties participated in the technical assistance. Based on HMA's standard review of implementation progress, we identified multiple opportunities to improve access to MAT for incarcerated individuals. Among these opportunities, facilities consistently attributed stalled implementation to lack of long-term sustainable funding and the Act's burdensome data reporting requirements. While many of our facilities have made great progress in implementing MAP programs, many cannot perform the appropriate standard of care due to these challenges. To mitigate the technical and administrative burdens on the local correctional facilities, our office is proposing to amend certain provisions within the Act, specifically striking data reporting redundancies. Although our county partners support repealing unnecessary reporting requirements, you will hear from them today about establishing dedicated state funding to improve and expand care to individuals that are currently incarcerated. GOCAP requests your support for removing these reporting requirements proposed in SB 282. The office also fully supports the county's pursuit of dedicated state funding to support substance use disorder in our local detention facilities. Full implementation of this act is a crucial step forward in combating the devastating impacts of some substance use disorder and mental illness within our communities. With that, I thank you for your time, and I urge the committee for a favorable report on SB 282.
All right, thank you to the chair and thank you to members of the committee for having me today. My name is Sarah Sample and I'm here on behalf of Maryland Association of Counties. And we are here to support this bill with an amendment, Senate Bill 282. Funding, as you've heard, has been one of the major barriers. This is something that the state was required to fund, but the money has not come through effectively. And we actually, thanks to Senator McKay and the detention center director in Allegheny County, we were able to get an AG opinion essentially saying that the programs are not required unless we do get the funding from the state. And so our amendments are really to help facilitate the state in compliance with the funding for this mandate. And so just a quick glance at some of the amendments that we have. We've got them pretty much line for line, the way that we would need to submit them to DLS. And the first one is a flexibility avenue for funding this. So the state could fund it through their portion of opioid settlement funds, or they could fund it through an appropriation. So the reimbursements only would draw on the opioid settlement funds to the point that the state needs to the point where the state is able then to provide an appropriation. So they can do it one way or the other. So we provided that flexibility. We've also got some reporting requirements so that we would have to submit a certain amount of information to the department in order to get the reimbursement. And we have a line there as well that says that the department can add additional requirements if they see fit. And then the last line is essentially saying if our reports are late, there's a deduction mechanism that the state can use. I don't think that fulfills the overall goal, but it's something that we wanted to put in there just to make sure that we were working collaboratively with the state. So in closing, I would just say we think after 5 years, this is the time to fix this. The recommendations from the advisory council are consistent with this use of the funding. And these are really vulnerable populations that are in our facilities. And we think partnership with the state is really the only way to make these programs really service the populations that they need to. So for those reasons, we would support this bill with an amendment and happy to answer questions.
Thank you, Mr. Chair. I'll end it with, isn't that so? But in Allegheny County, 82% of the people who are in our detention centers suffer from substance abuse. And in Allegheny County, we put a number that what it costs the county is approximately 800,000, just a little bit north of 800,000 each year. And the state was supposed to fund it. They didn't. We sent the AG's letter. And so I think it's really important that this bill gets passed this year for those that the state, if it makes a promise, it should keep a promise. And so I thank you for that. Isn't that so?
That is definitely so. And I have additional information on what it is costing some of the individual detention centers if anyone's interested.
Thank you, Mr. Chair. So over the years, the General Assembly, with the best of intentions, has passed bills without funding provided, only to find that they're very expensive. And this is just another example of one of those bills. So I wonder if I could talk to the representative of the state who's here. You heard the MACO and their problems with this, and there are no problems with the changes you want to make to the statute. They're simple. The problem is that these services aren't being funded and so are not being provided. Does the state have any response to this? Do you think the state is going to be capable of providing the funding necessary to provide these services?
So I'll say that and Brandy, jump in if I'm missing anything, that between our office, the Governor's Office of Crime Prevention and Policy, MDH, and the Opioid Response Command Center, we've provided grant funding to support, some implementation across some counties. We do know, and if you take a look at the annual report that we published about this program, that is one of the major challenges. The Opioid Restitution Fund is a source of money that I think could support these kinds of programs. I think just in the news last week, there was kind of an additional settlement that added to the money in that pot. And as I hear from Brandy and Sarah, who have been working on this issue for some time now, a council that was a part of kind of bringing this to fruition envisioned this as one of the purposes of the funds.
Okay, so I was on the task force, which some years ago pushed MAT. And we started, as I recall, in 3 counties. I think they were Prince George's, was it St. Mary's and Howard? Allegheny, okay. And then as the years went on, we were going to add more counties to the program, finishing up with Baltimore City, which was going to be the biggest nut to crack. And so here's this language here. It requires the state to provide each county funding equal to the cost of their medication-assisted treatment program for the following fiscal year. If we were to adopt that, would the administration have a problem with us doing this and requiring that the funding be provided starting next year?
The administration is in support of funding for this program, of getting this program fully stood up. Yes.
Okay, great. Thank you.
Thank you, Mr. Chairman. And I think I have a pretty simple follow-up. I think it was Sarah, you mentioned that you have some more numbers. So I heard 800,000 for Allegheny County. Do we have a ballpark sense of what the statewide number would look like annually?
Yes. Well, I can first say that it fluctuates depending on how many individuals are in your facility that would be on the program. We have, I would say, probably almost half that are going to fall somewhere between $200,000 to $500,000 a year. But then for some of the largest jurisdictions, that number is going to be a little bit bigger. But for Anne Arundel County and Prince George's County, I know they're both in the range of $450,000 to $475,000 a year. So they're under $1 million between the two of them. But we do have some outliers like Baltimore County. I think they're in the range of 2.6 or 2.7 million a year. The estimate that we had given to the Department of Health, I believe, was $11.3 million annually.
Great. Thank you very much.
All right, further questions from the committee? All right, thank you all very much. Thanks.
Thank you.
How's your son doing?
Oh, he's great. Well, he has hand, foot, and mouth this week, so
Oh.
not super.
Well, give him a hug for me. All right. Not this week though, yeah. All right. All right, with that, that'll end the hearing for Senate Bill 282. We'll now move on to Senate Bill 275.
Thank you, Chair Smith and members of the Senate Judicial Proceedings Committee. My name is Ross Cohen, and I stand here as the Deputy Secretary of Maryland's Department of Veterans Affairs and an Army combat veteran. I respectfully ask the committee for a favorable report on SB 275, waiving the fee for special registration plates for Gold Star next of kin families with an amendment to strike language on name and rank due to privacy concerns. I stand before you today to express our deepest gratitude and unwavering admiration for a group of individuals whose sacrifices often go unnoticed, Gold Star families. These families have paid the ultimate price, offering their loved ones in service to our nation, and their sacrifice is immeasurable. When we speak of Gold Star families, we are referring to those who have lost a son, daughter, spouse, or close relative in the line of duty. These families bear a burden that is both profound and heart-wrenching, yet they stand resilient, a testament to the strength of the human spirit. The Gold Star, symbolizing the loss of a family member in service, is a stark reminder of the sacrifices made by these extraordinary families. It is a symbol not only of grief, but also of honor and valor. Each Gold Star represents a life given selflessly for the ideals that define our great nation: freedom, justice, and liberty. This legislation will go some small way toward honoring and recognizing those lives and those families who gave the ultimate sacrifice. I respectfully ask the committee for a favorable report with the amendment.
Thank you very much. Questions from the committee? Senator Sidnor.
Just a quick question, and I'm sure it's defined somewhere, but who would qualify as a next of kin to receive this?
It would be someone whose service member passed away, but not in combat necessarily. So through an accident, something like that.
Sorry, say it again.
It would be the next of kin is the Pentagon's designation for someone whose family member passes away while they're serving, but not in combat. So they pass away through an accident.
Right. No, who would qualify as the next of kin is what I'm asking.
I think the person identified as next of kin by the soldier, by the passed away service member. So it could
Mother,
be
brother. I mean, that's what I'm trying to understand. Who? Because I don't know, so I'm just asking. Do you know who would qualify?
It's usually parents.
Okay.
It's parents or spouse.
Parents or spouse, not brothers or sisters.
I think generally not. I think generally it'd be brothers, parents or spouse.
Okay, thank you.
Seeing no more questions, thank you very much. Thank you. All right, with that, that'll conclude the hearing. Oh, sorry. My apologies. Please, thank you.
Good afternoon, Chairman Smith, Vice Chairman Wall Striker, and members of the committee. Thank you for the opportunity to speak on the importance of the Gold Star License Plate Bill, and I respectfully ask the committee for a favorable report with amendment on this proposed legislation. My name is Paula Davis, and I am the mother of Private First Class Justin Ray Davis, United States Army. My son was serving in the United States Army as an infantryman, supporting Operation Enduring Freedom when he was KIA in Afghanistan on June 25th, 2006. He now rests in a field of heroes at Arlington National Cemetery. My son, PFC Justin Davis, was a courageous, dedicated young man who had a passion for life, people, and most of all, a passion for serving. He wanted to be a part of something bigger and more important than himself. He was blessed to follow his dream with an infectious zeal until the very end. I know he gave his life doing what he loved. As a mother of a fallen hero who's giving the ultimate sacrifice for our country, I don't want my son's sacrifice to ever be forgotten. The Gold Star family's license plate is important because it's another way for our heroes to be recognized for who they are and for the sacrifices they have made for our country. It also provides an opportunity for people to pause and thank them for the sacrifice and service of our fallen heroes. The meaning behind the Gold Star license plate is so powerful. The license plate is a way our families can honor our loved ones' service and ultimate sacrifice. It helps to keep the legacy of our fallen heroes' selfless service alive. If one person looks at our license plate and realizes we are a Gold Star family member and our loved ones made the ultimate sacrifice for our country, then they are not forgotten. The license plate is a recognition of our loss. It's a solemn reminder of the dedication and character of our loved ones. The presence of a Gold Star license plate signifies that a family member has made the ultimate sacrifice in the line of military duty. Gold Star families' biggest fear is that our loved ones' sacrifices will be forgotten. Our loved ones didn't make it home. Their loss and that of the families must be ever present in our hearts, and the evidence of our curing must be continuously visible. We can never repay the loss, but we can honor, remember, and acknowledge the cost of freedom. I respectfully ask the committee for a favorable report with amendment on SB 0275 to ensure Gold Star families can easily apply for Gold Star license plate and recognize the stories of our heroes. Thank you.
Excellent. Well, I think it goes without saying that obviously your son has made all of us in the entire nation proud. So thank you for that. And you being here today are clearly going to make him proud and his memory and honoring his service and sacrifice. So thank you. And Mr. Cohen, thank you for your service in Afghanistan. I had a chance to visit Coast.
So that's where I was.
Yeah. And Mr. Secretary, thank you for being here for your support. All right. Further questions? Any questions from the committee? Thank you all very much. Thanks. All right, with that, that'll end the hearing for Senate Bill 275. We'll now move on to Senate Bill 254.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Chrissy Nizer. I'm the administrator of the Maryland Motor Vehicle Administration, here today in support of Senate Bill 254. Senate Bill 254 is a step forward to provide better accuracy for matching our insurance records. It requires companies to provide a complete book of business on a routine schedule to the MVA, as well as mandates participation in an online verification real-time service. The goal is to improve efficiency for vehicle owners, our law enforcement partners, and the MVA by tackling common burdens that are associated with this verification process. By having that updated book of business on file, the MVA seeks to accurately verify the insurance data in a timely manner and match insurance policies to customers' vehicles. As I said, it would mandate participation in the online verification system, which is today used by nearly 70% of our providers. We think it would provide great benefits for our customers as well as insurance companies with that real-time verification, and ultimately allow law enforcement to confirm insurance, which has been something they've requested in the past. Real-time updates also reduce the amount of what we like to call false insurance cases. That simply means at the end of the day, you wind up not paying a penalty because in fact you had insurance, but there was a mismatch in the records. I'm sure you may have heard from some constituents on these cases that we try to resolve quickly, but we recognize it's a burden not only on the customer, but on that insurance carrier to then try to send us the updated information. In fact, in fiscal year 2022, there were more than 2,000 lapsed cases that were closed without a penalty. The most common reason because they provided proof of insurance. That's a lot of customers' inconvenience, a lot of paperwork back and forth. We're hopeful that this new process will address those issues. MVA has been meeting with stakeholders to develop an efficient verification process and also an acceptable implementation schedule. We recognize changes need to be done and that some of the insurance providers will come with a January 1 implementation date. We are fine with that date and trying to make sure we want an efficient process for everybody and a streamlined implementation. With that, I would respectfully ask the committee's favorable consideration.
Questions from the committee? Seeing none, that will end the hearing for Senate Bill 254. Oh, I'm sorry, my apologies. Come on up. Mr. Popham.
Thank you, Mr. Chairman, members of the committee. Bryson Popham appearing before you for the first time this year on behalf of the Maryland Association of Mutual Insurance Companies, which is a group of small insurance companies who write automobile insurance in Maryland. And we also are supporting the bill with both the amendment that the Administrator Nizer mentioned and some other language that may not take the form of an amendment. I'll explain that in a minute. Since 1973, you have had to have automobile insurance in Maryland if you have a car. In 1985, I served on a task force in the House Economic Matters Committee. Throughout all of that time, we have not been able to enforce effectively our compulsory insurance, automobile insurance law in Maryland. We are hopeful and expectant that this bill will allow you to do so through, of course, the technology that's now available. I'm speaking to you on behalf of the small insurers who are in the automobile insurance market in Maryland, who have not been able yet to participate in the MVA's online verification system, but wish to do so. And they simply have requested sufficient time to develop their technology to comply with the online verification system. We've been in conversations with the MVA. They've been very cooperative. It's possible that we may be able to do this without a further amendment. I am hopeful and expectant that we will, but we do want to support the amendment that Ms. Nizer spoke to, which is the January 1st effective date. And hopefully we can resolve the other problem with short of having another amendment to the bill. So with that, Mr. Chairman, we're happy to support Senate Bill 254.
Thank you. My question is just really simple. So what I'm hearing is January 1st for sure is a timeline that you definitely need. So we have that amendment.
Correct.
And you're going to continue conversations as to if we need other language. Is that
Also
what we're
correct.
at?
Yes.
Wonderful. I just want to thank you for your collaborative process. JPR is known for collaborative stakeholder work. So thank you for continuing with that tradition.
Thank you,
appreciate it.
Senator. And I think credit goes to the MVA for that as well.
Thank you, Mr. Chair. So, Mr. Popham, I would love, this sounds great. So give me an example. If I buy a used car from the guy down the street How is, and I don't buy insurance and I start driving it. How am I going to be flagged and identified as someone who is not, doesn't have insurance for his car?
When you go to the MVA to change your title, you have to present proof of insurance. And that has always been problematic. And in fact, what you're really asking, Senator, is how is the system gamed?
Yes.
It's gamed quite easily. You can buy insurance and have it in effect, but only for a very short period of time. We have a system today where insurers are supposed to provide little paper pieces of paper as evidence of insurance. Those are out of date immediately as soon as they're issued. You can cancel your insurance as soon as you get that proof of insurance.
So how will this bill fix the problem?
Because it would allow, and really you should pose that question to the law enforcement officers who stop the cars on the side of the road and say, give me proof of insurance. This will allow them ultimately to have real-time proof in their cruisers that a car has insurance in effect.
Because the insurance companies are providing the information electronically,
right,
which is downloaded into the system.
To the MVA, that's correct.
Okay.
We've been waiting for a long time for this, Senator, so I'm hopeful it'll work.
It sounds great. Thanks.
Thank you very much.
Thank you, Mr. Chairman.
We're going to get a couple people together, try to vote this out in the next week or two. So if we could get some folks together this week to develop, if necessary, the forthcoming amendment that we do not.
Draft letter that will be shared and then shared with.
Excellent. Okay, great. All right.
It will be at your disposal, of course.
Okay, great. Mr. Enton.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the American Property Casualty Insurers Association. Our members write about 60% of the auto insurance in the state of Maryland. We are favorable with amendments. We appreciate the work we've done on this bill with the MVA. You have Ms. Egan, who couldn't be here today. You have her written testimony. The two amendments that we had suggested, one was to remove the effective date, give us more time. The second was to add some uncodified language dealing with what we do going forward to make sure that this works. And with those amendments, we have absolutely no problem with the bill whatsoever and would support it.
Excellent. Questions from the committee? All right. Thank you very much. Oh, sorry. I'm sorry. Senator Sidner has a question.
Thank you very much. Good afternoon.
I'm sure I can't hear you, Senator.
Question, these amendments, are these amendments something that I'm assuming you've discussed with the MVA?
I'm still having a hard time hearing you. I'm sorry.
Is the MVA okay with these amendments?
I think the MVA is okay with them to some extent.
So I think we agree on the January 1 date. I think some of the uncodified language they're proposing, we think we can cover in a letter to the committee, which will then be part of the bill file, and will express our intent to work with all the parties to ensure that if they're not able to implement by the January 1 date, there's some grace provided in how that happens. And so you will be getting a letter hopefully by the end of this week, assuming we can find agreement on that.
I think MVA has been very cooperative working with us on this.
The question is, have you been cooperative? Thank you.
Smile says it all. No, okay. All right. All right. Thank you very much, Mr. Enton. I assume Mr. Weintraub is not, you are representing from, is Mr. Weintraub here? You're speaking for Mr. Weintraub as well? He's signed up, so I just want to make sure. Okay.
Jason's over in the
Got
house.
It. Okay, great. Divide and conquer. Okay.
Thank you.
Thank you very much. All right, with that, seeing no further questions, that'll end the hearing for Senate Bill 254. We'll now move on to Senate Bill 267.
Good afternoon again. For the record, Chrissy Nizer, MBA Administrator, happy to be before you in support of Senate Bill 267. This bill would allow the MBA the authority to issue an official death certificate copy for customers that require documentation to complete that MBA transaction. We've been focused squarely on providing that premier customer service experience and modernizing our transactions at the MBA, including looking at how we can make other state resources available and accessible during MBA transactions, especially when a death has occurred. There's no more stressful time than somebody coming in change that vehicle title and remove a loved one during what is often a painful time. Under Maryland law, the applicant is required to present that death certificate with a change of ownership following the owner's passing. Currently, the legislature has allowed the MBA to print birth certificates, and it's really been a great customer service benefit to enable people to get that ID or driver's license in one stop without having to leave and go to a local health office to get the document. By extending death certificate services to MBA branches, it'll allow that same convenience again during a very challenging time. Currently today, where an applicant forgets or doesn't have the death certificate, they have to leave our offices going either to the Department of Health or to local health office to get that necessary information. From our understanding, it may be mailed to them, so it may be a period of time before they're able to return to us. This legislation would give the MBA the authority to access the Maryland Department of Health's database and retrieve the necessary information to print that death certificate right then and there. We would not charge any additional fee, only the fee required for the death certificate. The customer would leave the office with that death certificate to use for any other purpose that they might need. All the security and audit conditions to provide the service would be implemented in coordination with the Department of Health, just as we do the birth certificate today. Since enacting that birth certificate legislation in 2018, more than 4,000 customers have been able to take advantage of that service. With that, I would ask for your favorable consideration, as this is another step forward in our one-stop shop approach to provide government services conveniently at motor vehicle offices.
All right. Seeing no questions from the committee, thank you very much. That'll conclude the hearing for Senate Bill 267. We'll now move on to Senate Bill 277. Welcome back.
Thank you. Again, for the record, Chrissy Nizer, MBA Administrator. This is another bill that is really about premier customer service. We often ask our team, give us ideas of how we can make life better for Maryland residents. This bill represents that. Since 2015, MBA has worked with state agencies and other support groups, including nonprofits, to reduce the fee for homeless ID cards from $24 to $1. What we've realized is that even charging that $1 administratively doesn't make any sense to us. And obviously for a homeless individual doesn't make a lot of sense either, but you are the only ones who can authorize us not to charge the fee. We can't do that ourselves. We can only reduce it as we've already done. On an annual basis, we help between 800 and 1,000 customers in this way, and we think it would be a great step forward just to eliminate that fee. Additionally, Senate Bill 277 would address a challenge for our customers that work abroad as documented civilian contractors with the Armed Forces and State Department. Every month, MBA gets about 15 to 20 requests from customers who are deployed overseas in this capacity. The current law does not cover them, and so we're not able to go through the normal process we do with the military and other individuals that are covered under the statute to be able to renew their license so they can continue to legally drive. This bill would simply extend the current process to those individuals. Finally, Senate Bill 277 extends a non-graduated licensed learner's permit from 6 months to a year. This is really consistent with the policy the legislature has done with us in partnership the last few years. We extended the commercial driver's license permit as well as the graduating license permit from 6 months to 12 months. That gives people additional time to practice, to not feel that pressure of having to take the test when they're not ready. Certainly, if they are ready and they meet the requirements, they can test. But again, we want everybody to be prepared when ultimately they move forward. This will help motorcycle operators as well as individuals who maybe come from out of country and are going through that process. And so for all these reasons, we really think this is a common sense bill that helps all the residents of Maryland and in different ways have a better customer experience. I'd ask for your favorable consideration.
Thank you, Mr. Chair. This seems like a redheaded Eskimo. This is a bill reducing fees.
It is.
Well,
yes, sir.
Plaudits. Good for you. Thanks.
Our vice chair takes exception to that characterization. All right. We do have someone sign up in opposition virtually, but it is not here. Is that right?
Correct.
Okay. So if there are no further questions, that'll end the hearing for Senate Bill 277, and we'll move on to our final bill of the day, Senate Bill 285.
Good afternoon again. For the record, Chrissy Nizer, Administrator of MBA, here in support of Senate Bill 285. This bill would remove the requirement that the MBA charges a $30 restoration fee to vehicle owners whose registration was flagged as a result of an outstanding arrest warrant. This restoration fee was originally instituted to cover the administrative costs with enforcing that outstanding arrest warrant. However, MBA recently completed an IT modernization system, which brings all of our systems together, allowing us to be much more efficient and streamlined in the services we provide, as well as seeing when fees are really unnecessary and burdensome. This fee is outdated, and from an administrative standpoint, it really does impose a financial burden on somebody who probably is trying to get their life back on the right track and oftentimes is unable to pay it. So we have a fairly large uncollectible amount for that reason exactly. And so we're here before you encouraging the removal of the $30 restoration fee to lessen the financial hardship and increase organizational efficiency throughout the MBA. With that, I'd be happy to answer any questions.
Thanks, Mr. Chair. So what about the existing fees that have been assessed but haven't been paid? Are you going to forgive those?
Yes, that would be the intent if this legislation is passed.
Great, thanks.
And I should have mentioned it impacts co-owners too, because if you're a co-owner of a vehicle that has an outstanding arrest warrant on one of the owners, you are impacted by the flag and not being able to move forward with registration.
I do have a question for you, but I can wait till after the hearing. Thank you. Thank you.
So, all right, see no further questions for the committee. That'll conclude the hearing for Senate Bill 285 and our hearings for the day. 14 bills, 2.5 hours. Happy birthday to me. There you go.